Good morning to all of you. Video number 1397. Friends, in the last video, I told you that the implead petition, the language and tenor should be proper and you should not level any allegations against the judge. Now, we are going to discuss another case where the judges were directed to not to pass unnecessary remarks against the government officers particularly. The government officers, no doubt, they are doing service in the government. To whom they are serving? They are serving to the public. Maybe there may be some eccentric persons, there may be some people who do not care the public. At the same time, they have to do the public duty. That's why it is not his personal duty. In such a case, the judge should think of, or the judge should show empathy toward the government servant. At the same time, they should not pass disparaging remarks against the government officials. That is what is held by the Supreme Court in this particular clause against the Calcutta High Court. So you can see the case as Union of India versus Alapan Bandhopadhyay, who was the Chief Secretary of West Bengal state. You may be knowing. In the year 2021, in the month of May, I think, so this Chief Secretary, he was the Chief Secretary. At that time, he was embroiled in a tussle between the state and centre. So, our Prime Minister, Shri Narendra Modi, he arrived in West Midnapore district. At the time, normally, either the Chief Minister or the Chief Secretary of people, they should go and receive him. He was conspicuously absent. He is a central government employee. Chief Secretary is a central government employee, UPSC man. So, definitely, the government took it very seriously, Home Report, and they have asked him they have removed him from the post of Chief Secretary and asked him to come back and report in New Delhi in his parental department. But he did not do so. Maybe due to the advice of Mamata Banerjee or somebody, so he resigned for the job. But even then, for the settlement of pension and other things, he has to apply. He has to go to Delhi. So, in this connection, so since he did not oblige to the orders of the government and he approached the CAT, that is the Central Appellate Tribunal, that is Central Government Appellate Tribunal, right? CAT, just like AP Administrative Tribunal, Central Administrative Tribunal branch at Calcutta, right? No doubt. So, actually, before that, this man has to they have not supported him. Then he came to the Calcutta High Court. Calcutta High Court said, since he has resigned for the job, there is no necessity for him to go and appear in Delhi office. But once again, the Union of India filed a petition before the Central Administrative Tribunal, which has passed the order that this man, Alapan Bandhopadhyay, has to report in Delhi. That is much against the orders of the High Court. Then once again, he brought it to the notice of the Division Bench of the High Court. So, two judges, Sabyasachi Bhattacharya and Rabindranath Samanta, right? Now, they have taken it very seriously. When we passed the order that he need not be present, he need not go to Delhi, how the CAT can frame or can award the rule or judgment that he has to go and appear before the Delhi office. So, the orders of the Central Administrative Tribunal are unwarranted, and in this correction, now the real important point comes into existence. The court, High Court, Calcutta High Court, remarked that the CAT, that is Central Administrative Tribunal, is used as a favoured litigant. Government of India used CAT as a favoured litigant, and the modus operandi adopted by the Union of India, it has mala fides. It has no good intention, right? So therefore, the High Court expressed strong reservation and held that the CAT favoured the central government or Union of India. So please remember, serving the cause of justice, definitely it will be on much higher pedestal than serving the so-called government in power. Right? Now, the High Court bench observed that the order of the cat not only violates legal right under Rule 6 of the cat rules, but also it violates Article 14 of the Constitution of India, that is equality before law. Constitution, it is a grand norm. So when I discussed the Hans Kelsen's pure theory of law, I told you what is grand norm. That is the basic norm. Constitution is the basic norm of the government of India. So this action by cat leaves a bad taste in the mouth. Now, having seen all these remarks, when the Matter of Union of India filed a case before the Supreme Court holding that the High Court made harsh and disparaging remarks against the chairman of the tribunal and the government also, and therefore, now in this connection, I will read the Supreme Court observations. Supreme Court noted that the remarks made by the High Court were unwarranted and founded on assumptions, presumption, assumptions, that's all. So we have no hesitation to hold that they were wholly unnecessary. They were wholly unnecessary for the purpose of deciding the transfer. So the remarks passed by the High Court, they have been expunged. So here High Court is an authority. Yes, they can do and undo things. 151 CPC gives enormous power. 145 of the Constitution gives them power. So many Supreme Court and High Court have got powers. So they can utilize them, but in a proper way, but not using this type of language. So after all, he is a public servant. And I definitely should have heard the word of that Mamata Banerjee. Whatever it is, he has to follow the rule book. But somehow some mistake has crept in, he will correct. So he has already resigned. So for a resigned person, why should you take so much of stringent action? This is the attitude of the Supreme Court. That is what is called magnanimity. So very good judgment. Please read it and enrich your legal knowledge. Thank you very much.